All right, ladies and gentlemen, sorry for the delay, but welcome to our House Juvenile Justice Committee meeting. We're going to go ahead and get started. Representative Reeves, if you want to take the podium and explain what we are talking about here.
Thank you, Mr. Chairman, and Ms. Carter, if you want to come over, we'll just tag team here with the microphone and the podium. This is our second hearing on House Bill 913, which, for those of you that were not here at the last meeting, this is just for by and large, 95% of it is a cleanup, mostly a technical cleanup of the adoption bill from House Bill 159 from a couple of years ago. And as always happens with a major rewrite, after things have gotten into court, we realized some things could be worded in a better way, et cetera. And there was a couple of mistakes. And so those are being corrected. And we walked through all that last time. And so for purposes of today, there are really only a couple of things, unless anybody has questions, well, I answer whatever you want. But as far as what was carried over from the last hearing, there are only a couple of matters that I believe we're wanting to be discussed today. And so two of them, which I will get to in a second, involve striking a couple of one proposed change in the bill we're asking to strike, and that's 478 through 482, and we'll explain the reasons there. And then there's an error in line 1023, and the word pre-birth in that section needs to be struck. So those are two of the four amendments. But then otherwise, if I can just have everybody turn to page, page 17 of the bill. We're going to be talking about parts of the bill, the additions to this bill in Section 12. Section 12 of the bill deals with a lot of the fraud and illegal inducement concepts that we deal with in adoption law. And there was we expanded in line 584, we expanded a type of fraud that we have seen, and I have Julie Wizotsky. I did it, yes. Julie Wizotsky is an adoption lawyer in Athens, yes. And you're leaving tomorrow to go to the coast, right, to teach? To the Foster Parent Association. Yeah, so she drove over here from Athens today to talk about this issue, and is leaving tomorrow to go down to the coast for a conference. So we're very thankful that she came here today. She has dealt with the issues that are a lot of the reasoning for what we're looking to do with these new parts in Section 12. And so she is going to talk about what she has run across in her law practice, in her adoption practice. And we're going to talk about what number 4 means, and then moving down to line 594, what number 2 means. And for both of these sections, we do have some proposed changes in amendment language to better clarify. And this is some of the conversation that was left over from last time with Chairman Ballinger and a few other members of the committee to better clarify exactly what we're seeking to do here, so that we've identified it in a more pinpoint way. But so what I'd like for now is for Ms. Wizotsky. I did it wrong, didn't I? It's okay. God, see? All right.
See, I told you Dubnik wasn't so bad.
I know, right? Now I'm really messed up.
Why don't you let her introduce herself?
Julie. She's going to talk to us about some things she's encountered.
Well, and it's not really a hardship to come from Athens, because I have taken since last March every opportunity that I have been given to try to speak about this issue, because it is such an important issue, and that is the emotional adoption scams that have been happening, and in particular one that is based out of my area in Athens, a girl that says she's from Athens, claims that she's pregnant about to have the baby. You need to come quick. Do you want this baby? She's contacting families. In hindsight, we've come to realize that she's often working with 2 or 3 families at a time, promising them her child that doesn't exist. The security at our local hospital actually called me in and wanted to talk to me about the situation because he's concerned that he's had 20 couples show up to pick up a baby that's not there, and he's concerned that at some point somebody may be emotional and may do something that, that security may need to be called in. And so it's been a really big problem. With my colleagues just in the Georgia Council of Adoption Lawyers, I have heard of at least 25 situations, and I have spoken with lawyers in other states who also see this type of emotional adoption scam. I spoke with Emily Barrett from South Carolina this morning. She was telling me that there was a alleged birth mother who had said she was pregnant and had the couple fly in from Indiana. Of course, we all know last-minute plane tickets cost a lot of money, and they got a hotel here in Atlanta. And when they showed up at the hospital said, we don't know, this baby's not here. This is a very, when people are wanting to adopt, they've usually already been through maybe some type of emotional experience. Maybe they've been experiencing infertility or something like that, and they are excited about adopting, and so it's a very emotional time, and a lot of times that causes people to maybe not notice some red flags, but it also, the scammers are very good. I work closely with an adoption agency here in Georgia. They had 2 families that called, thinking that they had a baby, wanting to match privately, and it was an adoption scammer, and they had a hard time convincing the couples that it was a scam after doing some due diligence and realizing that it was, because the people were so committed. But what if? The problem, the people that I have encountered or heard of doing emotional scams are smart in the fact that they don't take money, and so there's no recourse. I've had lots of my clients asking me, well, what recourse is there? What do we do? We've called local law enforcement, we've called GBI. There's no crime has been committed. There's no necessarily any lawsuit that they can file. So what do they do? There's no recourse. They lick their wounds, they go back, they try to learn how to trust again, and they try to be careful. But that is where I've run into a brick wall with trying to figure out what do you do to help these people, and more importantly, or maybe equally as importantly, what do you do to stop the scammers? Because the one I've been working with, she knows that I've not taken any money, so they can't charge me with anything. And so, what do we do if people know that there's no ramifications to their behavior? Then I don't know how we deter them from doing it. And so I appreciate the opportunity to come and share my experience with you, as unfortunate as it has been, and with my clients. And I don't know if you have any questions or if there's anything else.
Are there any questions from the committee? Number 11, Representative Hutchinson.
Thank you. I just have a question. I don't have a problem with the proposed verbiage, but realistically, what do we expect to get from these people who, if they're doing this for emotional torture, are not well themselves, and they're usually not wealthy? So realistically are we going to get out of this?
Well, realistically, I don't know, to be honest. I do think that the fact that they know that something could happen may be enough to stop them, to deter them. Knowing that there's nothing in place that can stop them is just kind of a wide open invitation. I know in the one scammers that says she's from Athens, who goes by the name of Gabby, in her situation, her family has wanted to try to do something and has been unable to stop her behavior. Okay. And so I think that maybe just the threat of, you could be there's a law against this and you need to stop it. Maybe that would be enough. I mean, we can only hope. We can only do what we can do.
Okay.
Any other questions? Seeing none, Representative Reeves.
Thank you. And I think we had talked about this last time, Representative Hutchinson, but a lot of what we do in all kinds of laws, whether it deals with criminal penalties or the potential for civil penalties or civil causes of action, there somewhere in there, what we hope for is a deterrent effect. And for somebody that's out there doing this right now that might feel emboldened by the fact that they don't feel that there may be accountability for it, then perhaps, and the law is fluid, and I've said this a couple of times on another bill I've been working on this week that, welcome to 2020. Like, we are 2020, this is an issue that we're dealing with. And so it's something that one of our obligations in the General Assembly is to constantly be looking at conduct and activity that's going on out across the state and figure out how, as we shape public policy, not only do we create penalties, but hopefully we create deterrence as well. There are, you raise a lot of valid issues relating to mental health and competency for criminal actions, and those are things that are, the criminal justice system is embedded with a process to deal with those things and how those folks are dealt with in the criminal context. And in the civil context, you're right. Perhaps it may be that the folks, that the tortfeasor is not a person of means that would, if somebody were to sue someone for damages, they may not ever be able to recover anything. But those are considerations that happen. I think we set a policy, and those are the things that kind of follow that on a case-by-case basis play out. And so the way I always try to look at our role in this is to not make assumptions on those things based on how we know that some cases may be, but know that every case is different and every situation is different. And so this is really just a way to account for a very traumatic pattern that we're seeing. And so, but with that, what I'm going to now do is, yes.
You have one more
Okay.
question, if you will. Representative Oliver.
I've had a lot of experience responding. There you are. With trying to create accountability for people who may or may not be mentally ill, may or may not be competent. And what this statute will give us is opportunity for injunctive relief.
Mm-hmm.
And if somebody, I see this all the time, there is somebody who will say to a judge, I'd rather go to jail because I'm right. But most people will stop behavior if injunction is there. And that's really important in this area because these people are probably diagnosable in some way, but their conduct is intentional, if that makes sense.
Mm-hmm.
And they can change behavior if there is a reason and an injunctive relief.
That's right.
So I'm really thinking about it for the very damaging, hurtful behavior that I see and that I've used the courts, that injunctive relief would be the real remedy for this lady that you've described.
Thank you, Representative Oliver.
And obviously with injunctive relief comes a judge's ability to issue the power of contempt. And if somebody violates an injunction, then a judge, there's a big hammer there. And it's not a criminal proceeding, it's a civil contempt. And so it's a way to try to stop egregious behavior. And I'm going to have Melissa Carter from the Barton Clinic, who I know everybody on this committee is very familiar with, walk through you're looking at the bill right now. Does everybody have a copy of the proposed changes or no?
And Representative
Okay.
Reeves, I want to make sure we're working on LC 338212.
Yes, sir.
Okay, thank you.
So not everybody has a copy. I think we're about to hand out, but Ms. Carter is going to walk through the two sections at issue and then kind of talk about how we have proposed these potential amendments to try to refine the language to get us to a point where we have more clarity in exactly what we're trying to do here. So, just this and this, yes.
Okay. Well, good afternoon. So I'm sort of in an enviable position of trying to take this complicated and nuanced situation and offer some technical support in how we might capture that in this statutory scheme. And we wanted to take the inputs from the conversation of the hearing last week and really try to make more precise and curate a bit more the way that it was originally drafted. So I'll draw your attention to lines 584 to 589 in the original bill, and walk you through what we hope to offer as a reflection back to you of our response to the concerns that were raised about how a more vulnerable or sympathetic situation might be accounted for here. So looking at lines 588, 589, this creates then the crime of the false representations in the existence of a pregnancy or the intention to place a child for adoption when that person knowingly knows that that's not what they intend to do. You'll see then at lines 588, we start to describe, if you will, the injury that it results. So it provides that such representations, these being the false representations we've been talking about, cause another to expend money or take other specific steps toward adoption of a child in reasonable reliance on those false representations. So the feedback, the concerns that were expressed at the last hearing and the inputs we've received since then cause us to bring to you a proposed amendment to that area of that there lines 588 to 589, that particular language, that would then further specify not just expend money, but instead say expend substantial financial resources. There were conversations about actually trying to put a dollar amount to that kind of injury, and we really believe that something here that's a little more flexible and allows for some relative comparison of circumstances would be more fitting to what we're trying to do. $1,000 to one family is $10,000 to another in the relative sense of economic strength. So that's one fix, and then it would continue to read or take other specific steps, and again here trying to be more specific and describe by way of inclusion activities like including but not limited to significant travel, as you heard described, or retaining the services of an attorney, agency, or social worker, and then continue with the language that's there toward adoption of a child and a reasonable reliance on such representation. So again, here specifying the substantial financial resources, not just money, and then also adding then some specific activities to make more concrete what would be that step in furtherance of the reliance on the misrepresentation.
Any questions from the committee? Seeing none.
Okay. And then there's the related piece there follows on lines 594 to 597. This is in the context of tort, so the civil recovery for such injury. And here again, we're trying to tighten things up, or at least make things more clear, perhaps is a better way to think about it. The language currently reads, of course, any individual who's seeking to adopt or seeking to place a child for adoption who is damaged by a violation of this code section may file a civil action to recover all damages relating to the intentional infliction of emotional distress available to such individual under Georgia law. Rather than go ahead and characterize the actual cause of action as being intentional infliction of emotional distress, we're suggesting then to change the language to reference more generally the availability of any tort under Georgia law, so that section would read, starting at lines 595, would reference file a civil action, and then read to recover all damages relating to the intentional infliction of emotional distress available to such individual under Georgia. I'm sorry, read the wrong part. Forgive me. Replace. I was like, they're like, that's not what you're doing. In fact, here's what we intend to do: to replace that what just referenced incorrectly with to proceed under in tort, provided that such individual would have an existing tort claim under Georgia law.
Any questions on that? Okay, seeing none.
So those are the two amendments related to the conversation we've had and the discussion from the last hearing.
Representative Oliver.
You still want us to proceed with an amendment to delete 478 to 482?
Yes.
Tell me why, please, sir.
Why don't you list some?
Right. So on a separate matter altogether, outside of the context of the discussion we've had, and I draw your attention to lines 478 to 482 of the bill. and specifically to the entirety of what has been proposed as amended language there, starting in the middle of lines 478 with an affidavit and continuing through 482 in the middle that ends this subsection. The intention of this was to allow petitioners for adoption to receive an affidavit from the Department of Human Services that would then suffice for what otherwise they would have to do by way of obtaining another criminal records background check, to save them the expense and the burden of doing so. The fact of the matter is there actually is federal law that prohibits the sharing of that kind of information. And so notwithstanding the sort of, policy here that was attempting to be advanced, it really isn't something that's feasible. So the request then is to strike that amended language from 478 to 482.
In line 4, you wish to strike.
Yes, and so then the last amendment, that the sort of tightening up of this bill appears on line 1023. This is in the forms section. Actually, Justin Hester, for those of you who were here at the last hearing, spotted this. He spotted it just as a typo. So the context of that form is in the context of a pre-birth surrender, and all of the surrenders and their forms start off with kind of a preamble that says you have the rights to do all these things, such that it no longer makes sense to then restate pre-birth because you're actually executing the surrender after the birth. So it's just a typo. It really is of not intended to be of any import whatsoever.
Okay, thank you. Any further questions from the committee?
Procedurally, Mr. Chair, I think a motion to do pass, and then we can consider the amendments individually, if that's how the chair would like to handle that.
Absolutely, yes, ma'am. Representative Reeves, anything additional to add?
I do not.
Well, then, what is the will of the committee?
House Bill 913, LC 338212.
We have a motion to pass. Is there a second? There is a second.
And now I'd like to offer amendments, Mr. Chair, if you'd like to have discussion at this point, whatever you prefer.
Is there any discussion? Seeing none, are there any amendments?
I'd like to offer amendment to strike the underlined language on page 14, lines 478 through 482. Strike the underlined language.
You want to present them all?
You have to do all 4 of these at one time?
Just do them one at a time.
Is there any discussion on that proposed amendment? Seeing none?
The objection.
Second amendment will begin on line 588, and we're going to insert the specific underlined language and delete the word money, and then insert the word substantial financial resources. That is beginning on line 588. The existing language will take other specific steps and then include the specific language shown on your amendment, including but not limited to significant travel or retaining the services of an attorney, agency, or social worker, comma. Offer that as an amendment.
Is there any discussion on the second amendment? Is there objection? Seeing none?
And then lines 595, again on page 17, we are inserting the word, we're inserting in tort provided that such individual would have existing tort claim under Georgia law. And that's following any tort at the end of 597.
Is there any discussion? Seeing none, any objection? Seeing none.
Finally, on line 1023 on page 31, line 1023, we're deleting the word pre-birth.
Is there any discussion? Seeing none, any objection? Seeing none, we will offer this as the committee substitute. Are there any objections to the changes? Seeing none, we have a motion and a second. Do pass House Bill 913 LC 338212. All in favor shall say aye. Aye. Any opposed? Thank you. Are you up again?
I have 912 as well. This is a hearing only. May I proceed on 912? Or?
Yes, Representative Reeves, House Bill 912, and we are working on LC 338213. Is that correct?
That is correct.
You're up.
Thank you, Mr. Chairman. Members of the committee, and I have another familiar face for our committee, Director Tom Rollins, DFACS. Y'all, this bill is something that I'm really excited about. You know, I know that some of you weren't here a few years ago when we did all the adoption work, and being involved in that issue opened my eyes to something that I didn't come to the Capitol to seek to champion, but the issue, it kind of found me. And it's the thing that for as long as I get to come here and have the opportunity to be a representative, I want to pour as much as I can into this issue, and that's doing everything that we can do as a General Assembly to create a better foster care system and environment for foster children and foster parents. And we're on we're on the front end of what are going to be an effort to take a real deep dive into a lot of this stuff. And I think that over the next couple of years, the General Assembly is going to see more legislation that is similar in concept to what we're doing here, but one of the things that we were able to prepare to move forward on this year, and I love this bill, and I'm really excited about this, is this concept of a temporary caregiver that Director Rollins can explain in greater detail. But you know, one of the things that I want to do, I want this General Assembly to do over the next few years, is to identify. In some ways, y'all, it's the big picture, the big things, but in some ways, it's the little things. And this is one of those issues that's the little things, but it's something that we can do, we can tweak, that creates so much practical reception, positive reception by foster parents, that it makes life easier for them. And what we cannot continue to do is to move forward under the things that we do that are overly burdensome, that are unnecessarily burdensome. And so some of that involves creating some novel ideas, and that's one of the things that we have here. And I think if you talk to foster parents, the you know, I hate to use the word bureaucracy, but for lack of a better word, the bureaucracy that they have to go through to do the regular things that we all do with our families is overwhelming. And just being able to take mom and dad being able to take a weekend trip to the mountains, they can't just take their foster child and put it with the grandparents or have the child stay. They just can't do that without going through a lot of bureaucracy and red tape that makes it very burdensome. And so this is a concept that Director Rollins has worked up, and I'm going to let him walk through the details and take questions. But this is essentially to create a new status in Georgia law for a person to be identified as a caregiver, and that would allow foster parents to be able to have a child for a limited number of times a month, to have a child stay with that caregiver, and it reduces the burden of what they have to go through in order to achieve that, and it would allow them up to 72 hours to be able to take a weekend trip, do the things that regular people do. And so we're trying to make life easier for our foster parents. So Director Rollins, why don't you kind of walk through?
Sure. Afternoon, Mr. Chairman, members of the committee. Glad to be here as Representative Reeves. I appreciate him championing this bill. This is what I'd call a common sense reform. Just as way of background, a few years ago, the federal government really did allow us more freedom in doing what we should all be doing with children in foster care, which is letting them have a reasonable, free life, so that foster parents could, to some extent, let them do things that all children get to do. So we've adopted what we call the reasonable and prudent parenting standard, both here in Georgia and nationwide. That means that it's okay to let the foster child go and visit a friend for the night, go to the prom, go to the football game, treat the child in foster care as you would your own. This is to some extent the other side of that, which is let's treat foster parents as the licensed, vetted, responsible individuals that we have already deemed them to be, and let them get out of town for a couple of weekends a month with a regular babysitter without having to put that person through the burden of being fully vetted by some independent government agency. The way this law is written, it will apply to both our DFACS foster parents as well as to our private agency foster parents. I think it will be a great boon to our foster care recruitment. I think it will be a great boon to those organizations that come in to support our foster parents and want to volunteer their services as long weekend babysitters, for example. And I can walk you through the details, but I think it's fairly self-explanatory. I'm happy to answer any questions you may have about it.
Any questions? Yeah, I see you pressing the button.
Representative Cantrell.
Is
this thing working?
All right, we'll try the other one.
No.
Hey, just press it and stop. Hold on. Got to let it go. Go. You're live on.
There we go.
All right. I just want to say how grateful I am for Representative Reeves and for Director Rawlings for bringing this bill. As you know, Director Rawlings, we have a big organization at our church, and I discussed this issue multiple times with the previous director, and I believe we discussed it at breakfast that day when I introduced you to the folks that directed our church. And this is huge for retention. It's huge for recruitment, all the things you say, and we just need more common sense in government in everywhere, but particularly when it comes to taking care of kids. And so thank you so much for this bill. I'm excited about how it's going to impact kids positively across our state.
Thank you.
Representative Hutchinson.
Thank you for this. Thank you, Mr. Chair. This has been needed for a long, long time. So is it the federal law that changed that allows us to do this now?
Let's put it this way. When the feds adopted the reasonable and prudent parenting standard and required the states to follow it, and I think that was in Melissa Carter still here? Oh, there you are, Melissa. Was that the Strengthening Families Act? 2013 federal law. It did give us more flexibility in babysitting and reasonable and prudent parenting type issues. So I don't know if we could have done this before then, but I certainly think ever since then this is a change that we've been needing.
So are we going to push it a little further and let foster kids get their license at 16, 17?
They can get their licenses, but I think what we need to look at long term is how we can do like some other states have done, and perhaps figure out a way to make sure they have insurance and all that sort of thing. I would think that generally, there are some obstacles to it, such as insurance and such as liability and whatnot. But I think that long term we will be looking at that, because what we know that especially in Georgia, you can't get around without a car. I think we all learned to drive when we were 15 or 16, and we certainly want our children in foster care to have the same ability to learn that vital life skill.
And what are you paying your foster parents these days if they're able to take 2 or 3 weekends a month that they need a babysitter? Because I'm signing up.
Perhaps this is aspirational.
Okay.
Thank you. Representative Wilkerson.
Thank you, Mr. Chairman. Is there any concern at all about the age of 18? I have an 18-year-old, and I guess in foster care, I guess you up to what age are you in foster care?
You can, in terms of being covered by the more restrictive rules.
Like what age are we
until
covering?
When
What
you
age
turn
are we covering
18,
in
we
this?
have extended foster care, but we really do treat those folks as young adults. They're under a different rule. They may be in college. They may be out living in a transitional living program or something. So this, when we think really about traditional foster care and traditional foster care rules, we're generally thinking about those less than 18.
Okay, so you could have a 17-year-old being watched by their high school classmate. Is that?
I guess you
18-year-old
could,
classmate.
Representative Wilkerson. I think in reality what we're doing here is we have individuals who have all been through an extensive home study, who have been criminally vetted, whose background has been checked, who have had all sorts of checks done on them, and we are entrusting to the wisdom of the foster parents we have selected whom they should choose as a babysitter for a child. I personally, I'm not really. I think you could probably leave a 17-year-old by himself for a period of time. But I really think this is probably directed toward the younger children, and certainly we all, I've had my 17, 18-year-old niece watch my children for a week. It was a lot of fun when we actually got out of town. So
Correct. And I guess my concern is that anybody that has an 18-year-old, I'm just struggling with 18 years old versus a 21-year-old. If an 18-year-old gets in trouble, we look at it and say that's expected. They're 18.
mhm.
At some point, they start to mature. You can't drink until you're 21. There's a reason for that. You can't do many other things. There's just that growth that happens in that time period.
Mhm.
And to take someone that's trusted to the state, I'm just concerned about trusting an 18-year-old. And even as parents, if I have to go away, say there's an emergency, I may or may not use my best judgment. And so if we had that gap of 18, I'm just kind of struggling with that. That's the only thing. When I first heard that we were looking at using 18-year-olds, people in my district also were kind of shocked that we would do that. And I guess because our kids are all around the same age. And so that's where I'm just a little struggling. So
I think given a choice between having the regulatory agency make a call on an individual young adult's maturity level and having our vetted foster parents make that call about the individual maturity level of that potential babysitter, I'd rather defer that decision to the foster parent in whom we have placed our overall trust.
thank you. And so you don't have any issues with foster parents at all?
No.
You've never had any issues with foster parents?
We certainly have had issues with foster parents, but
Okay.
I think in 99.9% or 999% of the time, they are doing really good work, and they need to be encouraged to do that work
Okay.
and
Thank
do
you.
it in a way that they are able to treat these children as they would their own children.
Representative Hutchinson.
I wanted to address that. I may be quoting old policy here, but the last I was told, as far as leaving children alone and babysitting, that children between 8 and 12 can be left alone for 2 hours, and over 12, 13 and up, can babysit for up to 72 hours.
So there's, and I haven't looked at the policy lately, Representative Hutchinson, but I think there is something. So, for example, a 9 or 10, 11-year-old you can leave alone for a few hours.
Yeah, but
we don't
at
want
13, you can leave them for
Yeah,
by policy 3 days.
Yeah, but so in this situation, we're talking, of course, about a person who has been entrusted as a babysitter, who is an adult, taking care of a child for a period of time under the reasonable and prudent parenting standard. I would say that the amount of time that you can leave a child alone, of course, that guideline applies to all of us.
Right.
If my sister-in-law never left my nieces alone ever, my wife and I feel like our children are fairly mature, and we could let them have the run of the house for a while. But in terms of actual governmental policy, which is what we're dealing with here, I think we need to make sure that we are entrusting those case-by-case decisions to our vetted foster parents.
Yeah, my point was, if if I, as with my biological children, if I have the option of leaving them with a 13-year-old for 3 days, I don't have a problem with foster parents using their judgment for an 18.
Right.
Thank you.
Okay.
Thank you, Mr. Chairman. I just want to clarify. I don't believe that is the law. I believe it's once you get 16 or 17, you can be left alone. I thought is my understanding. So I just want to make sure that we're clarifying that. Plus, I just want to make sure that we're actually working on actual data before we put that out there. That
And I'm
you
sure
can
Director
think they
Rawlings
get-
can bring that to us, or Representative Reeves, before we have a move on this bill at a next hearing. But I understand both points there. And Director Rawlings, thank you for that. Representative Reeves, anything additionally?
Yeah, and I mean, I just, and I believe that the majority of the committee joins me in this belief. We've got to stop legislating to the 0.1%. If we want to break out of the shackles that have kept our system behind, that have caused the problems that make foster parents want to, who have the heart to do this, but decide I've done my time, moving on. We can't legislate to the 0.1%, and that's something I feel very strongly about, and I hope this committee will embrace that idea, not only on this bill but as we look to other stuff in the future. But I'll be around, obviously, for if any of you have concerns about this, to come talk to me, or recommendations to come talk to me. And I'll ask the Chairwoman Ballinger if we can have another hearing on this. So.
That sounds good, Representative Reeves. And again, I want to echo the other comments that have been made. I know this is, as you said, wasn't something you were necessarily looking for, but you've certainly taken this up as a cause that's very worthy, and I appreciate all your efforts. So,
thank you, Chairman.
Thank you very much. Chairman Setzler, you have waited very patiently, and I'm hoping that we're on the same page to hear House Bill 958 from you today. Make this a lot easier if that's accurate.
Sure, Mr. Chairman. It's your pleasure. I'm glad to make the presentation.
Well, the floor is yours, sir. Thank you.
Thank you, members of the committee, Mr. Chairman, members of the public that are here with us. Bring before you today House Bill 958. We're referring to as the Maternity Supportive Housing Act. What it does is it recognizes an opportunity to allow nonprofits and civil society to provide housing for women who are in the circumstance of being single moms and needing places to stay. As we know, in many circumstances, women could be in a, whether it's just economic hardship or other circumstances. There's a need across our state as women, again, typically single women, are wrestling with this issue of newborns and not being able to work and needing a place to stay it's a supportive residence that has just the right conditions to live in, to be safe, and to allow nonprofits or churches to provide a place for them. But there's a regulatory burden that gets in the way of doing this. And what's, in fact, Senator Renee Unterman has a similar bill, Senate Bill 307 in the Senate. And what we're looking to do is we're looking to create a circumstance where any nonprofit that wants to provide essentially a free or low-cost place for a pregnant mother or a new mother of newborn to live can do it without the regulatory burden that exists today in what's called maternity homes or other group homes. This was brought to us by people in the nonprofit community who have residences they want to make available to women, and found that between the ages of 18 and 21, there are actually some legal barriers to being able to do that. Recall, those of you who've been around for a number of years, about a decade or so ago, in the right-minded effort to make sure kids who are in the foster care system weren't just sort of thrown out at age 18 on their own, we began to provide services in the foster setting and in some other settings for people age 18, 19, 20, so they're able to receive some of the same services they had as older minors within the same system without sort of being tossed out on their own. And with that, the place we are in now as a state is that from maternity homes to provide care for 18, 19, and 20-year-old pregnant moms, there's a very, very strong regulatory overhang that makes them have a director and a whole series of things from a regulatory standpoint that's consistent with a group home or providing services, when all these residences are seeking to do is provide a free or very low-cost place for someone to live while they're kind of in this period of transition. So what House Bill 958 does is it allows, from a regulatory perspective, 18, 19, 20-year-olds to be provided services consistent to what 21 and older can be provided now, which is really in a largely deregulated environment where a safe place can be provided without the regulatory overhang of being a group home or that would apply to foster kids in our system, or what's fastened now as a maternity home. So what HB 958 does specifically, Mr. Chairman, and I'm glad to take questions at any time, I'd like to walk you through Section 2 of the bill. What it does is, it's a residential home. We contemplate this being, it could be in a residential neighborhood, it could be something that's built to residential code next to a church or a nonprofit's facility. It does have that nonprofit or church requirement. So we know there are churches across the state now that want to do this, but are wrestling with, do we need to build this to a commercial building code similar to a sort of a health clinic, or some of the higher building standards that are more costly and more burdensome, or if there's a home that's available now that meets code, that's safe, that can be occupied by any other family, we'd like to furnish that. But if the women in question are in the 18, 19, and 20-year-old population, they're precluded from being able to do this without this very heavy regulatory overhang. So right now, these kinds of facilities can only serve women over the age of 21, and this really looks to focus on those younger women in an environment that doesn't have the regulation that exists today.
Okay. Representative Oliver, did you have a question?
Yeah. I've been on boards of group homes, and I have familiar with churches in DeKalb County that provide pregnancy homes, and I'm a little bit familiar with the independent living program, which was a federal program that extended foster care benefits over 18. I can't figure out exactly what you're talking about here in terms of what exactly is the regulatory system that you're trying to avoid.
Okay.
What statute, what section, what agency, federal or state, are you trying to avoid to set up a house for adult women who are governed by local codes, housing codes? I can't figure that out.
Sure. Appreciate the question. I'm not going to be able to quote the code section specifically today, but the issue we find is that if people want to, as an act of benevolence, provide a place for a 19 or 20-year-old, for example, there's a retired couple that has 3 unused bedrooms in their house, that has no familiar relationship with someone, that wants to make that available to them, it's not clear that that's not a maternity home that needs to be regulated as a maternity home.
I think that is, since both of us are talking about things we're not certain of, since I can't figure out what you're talking about and you don't have a statute to show me, I think that adult couple can provide a home to anybody they want to, as long as there are not more than 6 unrelated people in the home.
I believe that's only true if they're over the age of 21. And that's what this seeks to address.
Okay, you're going to show me that statute.
I'll show that for you, yes, ma'am. I sure will.
Thank you, Representative Oliver.
There's a lot of different maternity homes around now.
Mm-hmm. The issue is, and again, I'll bring it back for the lady, and I appreciate that. That's why I want to go to the crux of this issue. This really deals with the ability to serve the 18, 19, and 20-year-old population in an environment that is not heavily regulated. If they're over 21, there's really not a regulation at all. It's just you furnish a space for somebody, and you're able to provide that to them as you would any other rent or free arrangement.
I'm happy to drill down in the law with you on this, but right now what you're saying doesn't compute with me in terms of 18 to 20-year-olds having a specific regulatory oversight from some agency. That's where I'm lost, because I know how group homes are set up. I've litigated with neighborhood associations on that and code enforcement associations about that, and that's not a... So we're going to do some more work on this to figure out what it is you're talking about.
We certainly are, and I appreciate the question. This is, again, it was a hearing only today. I wanted to go right to the root and explain kind of the contours of this bill, the way we've structured it. For women who are over the age of 21, there really is not a regulation. It's, I mean, you can, you know, the only thing you might be subject to is there a limitation in your specific county or city that would say a limitation of the number of households that can be under one roof. One of the reasons we limited this to a nonprofit or a church reference is that what we're looking to do is we're looking to have these homes be treated in the same way that a single family would be treated. So if you've got, for example, 3 women that want to be in each of the 3 bedrooms in a home of someone, they could live there. If they're pregnant through their child being 18 months of age, they're able to do that in a way that would allow them to be treated from a local ordinance perspective as a family. That they couldn't be regulated out of existence because of this issue of having only one household under a roof. That's one of the things that kicks people over into this regulatory this regulatory set of conditions where you've got to demonstrate it's one of these regulated entities. You can't just, for example, in Cobb County, you couldn't come in Cobb County and have 4 households, you know, a 18-year-old head of household, 20-year-old head of household, and a 19-year-old head of household, living with a 71-year-old missionary couple, for example, that came back 10 years ago from missionary work. They couldn't, that'd be 4 households under one roof, and that would run afoul of ordinances that affect multiple households within one home. So what we're looking to do is again, that issue from a local ordinance perspective would be allowable under this, that they wouldn't be treated as 4 households. They would be treated from a code perspective and from an ordinance perspective as one. But they would have to, as the bill states, Mr. Chairman and members, they'd have to register with the department, pay a $25 per year annual fee, demonstrate that they have insurance that covers the home, homeowner's insurance that contemplates the residents. And if you'll turn back here on up to page 2, lines 34 through 35, that they're in compliance with applicable residential building code. We don't want to have a home that doesn't even meet minimum code, that we're providing some sense of imprimatur to that's not up to basic safety standards.
You're going between local ordinances about no more than 6 people unrelated to the house. You're going to state law, what you're trying to create, and then you're talking about federal reimbursement rates for independent living people. And so I've got a lot of confusion here.
Again, to the lady's question.
Talking about all 3 of those at
Sure.
once.
Again, that's why we're stepping into this carefully, and I appreciate that we'll take the slow walk through that. Once again, one of the things here, there's no services being provided. There's no reimbursement here.
There's no tax money.
There's no tax money.
Exactly.
So there's, from the perspective of there being a regulatory overhang on these, to regulate these facilities, there's no tax money here.
For legal adults only.
It's all legal adults. But where we stand today is because of this issue of the way maternity homes are defined, existing facilities today feel like they can't serve women under the age of 21 because the definition as it exists largely in rule, prohibit them from serving them without falling under this regulatory burden.
And Representative Oliver, I appreciate all the questions, and Mr. Chairman, I appreciate your offer
Yes,
to
sir.
work on that. But I, in the essence of time today and other questions, I hope that you will work
Yes, sir.
together. I know that Chair Lady Ballinger would ask the same thing.
We certainly will.
Representative Hutchinson.
Thank you, Mr. Chair. I have a question about Section 2, line 18. The term should not include women who receive maternity care in the home of a relative or in general or special hospitals.
Yes.
That seems to, that seems like everybody would not be included in this.
Yeah, what we're wanting to do is, we're not, by defining this in code, we don't want the shadow of this to be cast across groups that don't need to be included. If you're staying in the home of a family member, there's no regulatory burden at all. If you receive maternity care, or you're in a general special purpose hospital, this makes sure you can't misunderstand what we're doing here is to apply to hospitals by deregulating hospitals. In fact, if you look on the second page, there's other things we say, it's not the same as a maternity home. We're trying to make sure that these can't be, this bill doesn't, in an unanticipated or unintended way, create any kind of regulatory impact that it doesn't intend to. It's really narrowly drawn just to circumstances where you've got a private home, no tax funding, no dollars, they don't provide services, it's just a residence, to make sure they're not going to be, there's no potential to be overregulated in that way.
Any other questions for the author? Mr. Chairman, anything else to add?
Mr. Chairman, I appreciate the opportunity to present this. I'd be happy to talk to any members of the committee that have more detailed questions, and I will be happy to talk to Representative Oliver on the details. Just
Thank
appreciate
you.
the opportunity to present.
Thank you. If there's nothing else at this time, we will stand adjourned.
Thank you, Mr.
Thank
Chairman.
you.